IP Litigation 2020 Year in Review. A flurry of jurisprudential development marked 2020 as a significant year in intellectual property litigation. The Federal Court of Appeal settled the law on some crucial issues that have longed for legal certainty and pivoted from established law on other issues. Numerous rulings at the trial level also feature interesting interpretation of legal points which forecast a lively 2021 with important ramifications to be monitored. Keeping on reading our recapitulation of 10 key legal topics that were discussed in the case law during 2020, to stay abreast of the emerging legal trend affecting the IP litigation landscape in 2021 and beyond. Jurisdiction. In South Canada, the Federal Court of Appeal held that a determination of patent ownership that hangs upon the application and interpretation of contract law principle was within the federal court jurisdiction. The guiding authority on this issue had been that the federal court lacks jurisdiction if the matter relates primarily to contract law, even if the central question is one of patent title. This has now been reversed as the court found that law not binding on the court and incorrectly decided. Justice Tredas reasoned that the federal court jurisdiction derived from 52 of the Patent Act, which provides that the federal court has jurisdiction to order that any entry in the record of the patent office relating to the title to a patent be varied or expugned. Since the application before the court in South Canada showed just that, he held that the federal court ought to have jurisdiction. Early this year, in McCain Food Limited Junior Simplot Company, the Federal Court of Appeal had another opportunity to comment on the extent to which the federal court has the jurisdiction to decide contractual issues arising in the context of a patent matter. In a patent infringement action, the defendant was alleged to have infringed the plaintiff's patent and wasn't permitted to bring a third-party claim against its supplier for indemnification. The court held it had no jurisdiction to adjudicate the indemnity issue. It was not enough that the indemnity claim was connected to a claim for patent infringement. The essential nature of the indemnity claim was held to be a claim in contact. The Patent Act was not directly relevant to the third-party claim. Summary judgment and default judgment motion. Our 2019 litigation year in review discussed whether summary determination of patent infringement claim following Canmore was a trend for a day or here to stay. This year, the federal court has seen increased attempts by litigants to resolve matter more expeditiously by way of dispositive motion. Summary judgment was granted in 3 cases, and 2 motions for default judgment were brought but dismissed based on insufficient evidence. Notably, in healthcare company Gilead Sciences Canada, the court held that completion of discoveries isn't a precondition to summary trial, such that resolution may be sought at very early stages of the proceeding. We saw the federal court grant summary disposition to dispose of claim construction argument, hold the patent invalid for obviousness, and dispose of a patent infringement action recognizing that the infringing product didn't fall within the scope of the asserted claim. Expert and claim construction. In 2020, we also saw more judicial skepticism with respect to blinding of experts, particularly in respect to opinion on who is the hypothetical skilled person of ordinary skill in the art, what her common general knowledge is, and how she would construe the claim in the patent at issue. For example, in Seeding Life Science Ventures, Caesar Canada ULC, Justice Kremen held that whatever the merits of blinding in other respects, I must say that it is not particularly helpful with respect to the skilled person, common general knowledge, and claim construction. In another case, the court signaled that this skepticism appears to arise from structural problems that impede effective blinding. A blinded expert will be expected not to have read the patent to avoid hindsight bias, but a business is assessed from the perspective of a skilled person, and determining who the skilled person is requires reading the patent. Thank you.